Hi, before you get into the thread of discussion, there was some stuff I meant to talk about last night but did not discuss. And that's the concept of unconscionability in contracts. Now, your book talks a lot about fairness in contracts, and that's a consideration, but I don't think it really tells the entire story. When a contract is, normally courts favor enforceability of contracts. Courts don't normally look at issues of was the contract fair, or could the parties have made a better deal, or was a decision that they made ill-advised. There's a presumption that a contract is freely entered into with a mutual exchange of beneficial promises. So the issue of unconscionability or subjective unfairness in a contract really doesn't get raised all that much, and most courts don't pay a whole lot of attention to it. There are some instances where unconscionability is an issue. First of all, in a commercial business-to-business setting, unless there is fraud or concealment or some other factors, courts rarely find commercial business-to-business contracts to be unconscionable. Where you do run into them is in about three major areas. The first is employment contracts. What a lot of employers have done to avoid liability under our discrimination laws or state laws or federal regulations is put provisions in their employee policy manuals that require that an employee arbitrate any employment law claims with the employer. Now, some courts have had problems with that because some of the ways employers have done this is to stack the deck in their favor. For instance, springing this requirement on the employee after the employee has already accepted employment, so they had no chance to bargain over it. That's one issue. Another issue is when the arbitration provision isn't mutual. For instance, some companies have said that an employee has to arbitrate all of their claims against the company, but the company's allowed to sue the employee in court. Other companies have done things like in the policy manual requiring that the arbitrator make certain findings. For instance, in a wrongful termination case, some employers have put provisions in that says the arbitrator has to make a finding that the employee was an at-will employee, which means they can be fired at any time for any reason. Other employers have tried to put provisions such as waiving workers' compensation benefits or waiving rights under other federal statutes and state statutes that violate public policy. So you see it in employment context. Another area you see it is in contracts between businesses and consumers, where the business is taking unfair advantage of the consumer. One big area you see it in is dealing with illiterate consumers. If the person does not read English, cannot write, when they sign the contract, it's not really clear if they're really agreeing to anything or if they're just signing papers. So if you're dealing with an illiterate consumer or a disabled consumer, that's another area where they may find a contract to be unconscionable. The last area of unconscionability deals with family law, and that is with regard to prenuptial agreements, which are agreements people enter into before they get married. Some people have tried to avoid liability for child support by having one spouse waive the right to collect child support. That kind of contract the states will throw out almost every time. Now, when you're looking at unconscionability, you also have to look at the procedure in which the contract was executed. So that's procedural unconscionability as well as subjective. So if a person was drunk, if a person was intoxicated, if a person was mentally disabled, at the time they entered into the contract, holding to that deal may well be unconscionable under some circumstances. Also, if terms are hidden from the person. For instance, in a lot of contracts you see terms, well, these are incorporated by reference by this document, and there's a 400-page document somewhere else that the person never sees. So that kind of issue could be procedurally unconscionable. The substantive deals with, is the deal so grossly unfair that it can't be enforced? And again, if the people are giving up certain rights that violate public policy, that's where you might see unconscionability. Another area where you might also see it involves arbitration provisions, where a person is required to arbitrate a small claim in a state across the country from them, or that they're required to, pay punitive damages in the event that they lose. There's some kind of goofy provisions like that. But when you get into the discussions, into the threaded discussion questions, you have to remember that unconscionability is extremely, extremely rare. In 17 years of practice, I think I've run into one case where it might be applicable. So just know that even though it's out there, that it is rare. It may work in the right case, but it's not something that you're going to run into every day. Thank you.